Yes, you're right.
Yeah, so you guys have like 3 more years with you. So you can, if some one of you have not yet started mooting, then you can start right away. Like there are so many moot courts going on in our country nowadays in virtual mode even. And if like physical things come, then there are around 300 moot courts that goes on a particular season. That is from June, July, August, September, and then November and all. So there are a lot of moot courts in which you can take. Now the thing is that how you should choose your moot, like how you should choose a particular moot court, and how should you go with the researching part, right? So the first thing is that you can know about moot courts from Law Octopus, and there are many other websites where you can know about a particular moot court. There are like a number of national moot courts going on right now even. So after like getting a particular proposition, you have to read the facts of that particular proposition and see that if you are comfortable with the facts of the case and the law that has been dealt in that particular proposition. Now suppose you are in your first year and you have not been taught the international law or international maritime law and all, or space law thing. So you don't know about all these law in your first year. So you may abstain from like taking up those moot courts. And if you feel comfortable, then you can choose a particular moot court which is dealing with constitutional law or Indian Penal Code or tort law or consumer law or anything like that. There are like lot many moot courts on different types of laws. Even environmental law moot courts are there, international law moot courts are there. So likewise, so you have to choose a moot proposition which is within your boundary and is comfortable to you for like winning a particular moot court. Then after choosing a moot proposition, you have to find two members. Like national moot courts always provide a cap of 3 members of a team from a particular college. So you have to find 2 other members with whom you are comfortable. I see that I and another speaker too will be working on a particular proposition, and the researcher will not be doing anything in that particular moot. So that is like not a wise situation for winning a moot court. So you all three of a particular team must be on same page and must have same enthusiasm to like take up a moot court and then win it. Your ultimate aim should be winning a moot court, right? So all three must have compatibility with each other. Now the next thing is that you have to read the facts of the case again and again. Now why you should read your proposition again and again? First of all, you will get to know the facts very well. Second thing, whenever judges will ask questions from within the facts, you can answer it promptly, which also fetches a like grace mark in your oral rounds. Next thing is that when you read your proposition again and again, you will get to know various other points like which you have missed earlier. So you will get to know new points whenever you read a particular moot proposition again and again. So you have to memorize it particularly thoroughly. And then the next thing you should do is that you should discuss the facts of the case with your teammates. Right now, the obviousness of this rule makes it ignored by most of the like mooters. So they don't discuss the facts with the teammates. They directly jump into discussing the law, what are the laws dealt in that particular proposition, and they ignore the facts part. But I would like recommend from my experience that you should first of all discuss the facts, like what all has happened, what are the timelines, what are the date sheets, which you should remember, and all three must be on same page, so that whenever a question comes to a speaker, another speaker or researcher can answer from within the facts itself. Now you have to stick within the particular facts. You cannot imagine something else from beyond the set of facts given to you in that proposition, right? So these are all importance of a fact sheet and how you should go about with your fact sheet. Now, after knowing your fact sheet properly, you have to make a sheet wherein you have to lay down all the dates or timelines, as I said. Now, suppose if you are dealing with a criminal moot problem, right? So there must be a date of registration of FIR. There must be a date of like cause of action if it is a murder or something else, right? Then there would be a date of filing of charge sheet, and when seizure report is filed and when witnesses are examined and all. So all these you can mention serially in a particular sheet, by which you will get to remember your fact sheet properly. So this is a particular way by which you can know your facts very well. I personally follow this way. Like even if the moot proposition is dealing with any other law, then you can make a timeline and paste it on your laptop screen, like small stick notes, or in your wall opposite of your study table, in front of your study table, right? By that you will know your facts. Now there are two important things. There are two important facts that you should know. One is undisputed facts, another is disputed facts, right? Now on the part of undisputed facts, you don't need to do much of your work, because undisputed facts are those facts which are agreed by both the parties, right? So you don't have to work much on that, but you have to work on disputed facts. Why? Because disputed facts are those facts which are asserted by one party and denied by other party. So you have to argue from both the sides by proving your points, inculcating all the arguments, case laws, and all, and putting down your facts relating with your facts. So you have to find out what are the disputed facts within the set of facts given to you in the moot proposition by the host institution. Now another thing is there that most of the host institution give a one-page introduction or one big para introduction, which you can absolutely ignore. Like in constitutional moot courts, I have seen that they will start with Indica got independence in 1947, then they draft constitution, etc. Constitution of India came in this year and all. So all these things are unnecessary for your the original facts that you should deal in that particular moot court. So you can ignore that first two paras or first three paras, which are introductory in nature and are not necessary and are not line with your fact sheet arguments and all. So you can ignore that. Now, as I said, you have to find out disputed facts. Why? Because disputed facts will make issues of your moot proposition. Now, while dealing with the memorial, I will say you how to find out issues and what are the probable issues and how to find out for the first year students who are new to this particular moot court thing. Now, after dealing with your fact sheet, you will directly go to researching about your moot proposition, right? So for starting off your moot proposition, you have to see what are the laws and what are the statutes which can be dealt in that particular moot proposition. Suppose, as I said, if we are dealing with a constitutional case, then obviously constitutional law, the Constitution of India will come into picture. Now, if the constitutional moot problem is dealing with the constitutional validity of a particular act or particular section of a particular act, then you have to read that particular act. Now, suppose and the moot proposition is providing that you have to deal with the constitutional validity of Farmers Act. Now you have to read that Farmers Act particularly to know that what are the faults and loopholes are there in the Farmers Act on the side of the petitioner. That will also help you in knowing that what are the defenses that you can take, what are the prospects, what are the benefits of that Farmers Act for defending it on the side of defendants or Union of India, right? So you have to read that Farmers Act particularly. So the meaning of saying is that you have to read a concerned statute or concerned law in consonance with your fact sheet. Then after reading and understanding the statute and the law dealt in your moot proposition, you can start reading the commentaries on that particular law. Now suppose if we are dealing with a case of acid attack, right? So for acid attack, you can start reading commentaries like Ratan Lal and Dheeraj Lal is there, D.D. Vasu is there, Nelson on Indian Penal Code is there. So you can start reading the provision of acid attack from these books, wherein you will get a number of case laws with their short ratio decidendi, and you can take all the favorable cases from both the sides and then note it down in a word file, right? So which will help you framing your arguments and citing authoritative judgments for your case. So after Reading down the commentaries, you can then jump to the online resources. Like SEC Online is there, Manupatra is there. Right. Now, I would also like to mention here that uh, there are so many colleges wherein SEC Online or Manupatra is not provided to the students. So, in that case, what you can do is that you can search your cases from submitted before the court, because that is not acceptable as per the recent judgment of the Supreme Court. Right. So but for researching thing, you can like do it in Indian Canon. Apart from it, there is another good website which I personally use is casemind.com. So you guys can note down that if like you are new to it, casemind.com. So casemind.com is a paid website, but it provides free service for students. So you have to just log in into it with your student ID, the particular roll number or any ID which has been given to you, and then you will access the website and all its features freely. So that is like a user-friendly website which helps you researching a particular case on a particular set of facts easily. So you can use that. Now the next thing is that if you don't have SCC and Manupatra, then how will be proper format and which will be proper for the bench, and they will not discard it. There are two websites which you can note down. First one is sci.gov.in, which is Supreme Court's own website, sci.gov.in, and then another is judice.nic.in. Judice is Supreme Court's website, but then it is maintained by its administrative side. But it like uploads authoritative and proofread judgments.
Can you repeat
So you
the
can,
sites, please?
yeah, sorry.
Can you repeat the site,
Yeah.
please?
The first one is sci.gov.in, and the second one is judice.nic.in. So you can download judgments from these two websites, which the court will obviously accept because it is the website of Supreme Court. Now you have to just like get the name of that particular judgment, or the date on which it was delivered, or the judge's name, or the case number. By using any of these things, you can like download a particular judgment from these two websites if you don't have SCC or Manupatra thing with you. Now the next thing is that after researching all these things, you now the another important thing is that while researching all these things, you have to maintain a sequence. You maintain all these things simultaneously, because what happens is that you write an argument. You know that you have read it from a judgment, but then you don't know what is the particular case. Like will be easier for you to compiling it and while submitting the Moot memorial to the hosting institution. So it will be helpful in that. So you should do that simultaneously. So after compiling all these things, you can then read the Law Commission's report or UN report, or suppose if you are dealing with a case wherein you have to cite crime rates, so you can cite NCRB report, right? So all these reports you can like find out in Google and then read it and make it use as per your like side and argument. So there are various reports on different like various topics which you can find in Google absolutely. Now then after finding reports, okay, then now the bench ask you that why UN reports will be binding, or why a particular convention or treaty will be binding on us. Like anybody of you know the answer? Raksha, if you like, you can say it.
Since there are treaties which are already passed by the appropriate authority, we can rely on the same.
No, but why Supreme Court will take it into account? Because
Since
that treaty is passed in United Nations, no?
so because
Indian?
India is part of the United Nations.
Not
So
in all
we
the
are
treaties.
not in all the treaties. We have the nuclear unification, which India is not part of it. So we are part of the few treaties which India
Yeah,
can take up.
the first thing is that India should be a signatory to the particular treaty that you are citing for your argument or in your memo, right? Another thing is that you can write down there are four particular articles of the Constitution of India which you can like UN reports or conventions or treaties are binding on us. The four articles are Article 37, read with Article 38, read with Article 51C, read with Article 253. Now, combining all these articles, the particular treaty that you are citing will be binding on a Supreme Court. You can like go and read down all these articles after this session ends. Okay. So this was one of the important thing. Another thing is that there are commentaries which like provide outdated or overruled judgments. So now after like getting judgments from commentaries, you have to check that if that particular judgment is still existing or is overruled by a Supreme Court's judgment or a High Court's judgment by a like larger bench. So you have to find that also while citing. Like in one of my moot courts, the opposite team have cited a case, and I in rebuttal said that this particular case is overruled. Now the other party denied that no, it is not overruled. But I have like taken that particular case with me in separate compendium. So I like gave it to the judge, and that was an impressive situation and like positive situation for my team. And like I have won that particular round also. So you must remember that you shouldn't take overruled judgments or you shouldn't cite any overruled judgments in your moot memorials. So you have to check that. You must be like aware before citing all the judgments if they are still existing or not. Then you can also take into account the opinion of judges. Like recently, Justice D.Y. Chandrachud have given his opinion on right to privacy and data protection and all. So you can also take that into account if your moot proposition is dealing with the data protection bill or data protection bill or anything connecting with that. So you can take down the opinion of judges, right? Now, another thing that you should remember is the hierarchy of judgments, right? So, can anybody say me the hierarchy in Supreme Court? Like, if anybody has read Constitution of India or have done some of moot courts on constitutional law? Anybody, like anybody can volunteer. Raksha, you can try now. Like I know you personally, so I have to ask you again and again.
Since I don't have much idea about the same, Devashish, since we are still in our second year and still completing the constitution.
Okay, so okay, then I will put it down. So first thing is that hierarchy in Supreme Court. I am telling you from the lawyer side. Okay, so it is single judge bench. Earlier there was no single judge bench thing like in the middle period. In the starting like 1951 afterwards there were single judge benches, but then it was discarded and there were division benches only, right? But nowadays single judge bench is there. So the lowest is single judge bench in Supreme Court. Then is division bench comprising of 2 judges. Then the bench of 3 judges, that is called a full judge bench or a full court. Okay. You guys can note it down because there are many situations or moot courts wherein judges will grill you on this particular point even. So you must like know the basic thing like this. Then after 3 judge bench, there is 5 judges bench, which is also known as constitution bench. Now all the benches above 5 judges bench are known as constitutional bench. Now, like, can anybody say me that why 5 judges bench or more than 5 judges bench are called constitution bench? Anybody? You can make a wild guess, like why it is called a constitution bench. Okay, so like I will put it down. The five judge bench or more number of judges bench are known as constitution bench because they can only interpret or they can only deal with a case which contains an interpretation of constitutional law. Like I would like to give you an example that if a case deals with Article 223, which is a provision dealing with the appointment of temporary chief justice, right? So there was a case I have read like much earlier that in that particular case the facts were like that an acting chief justice of Assam or like any other region has filed a writ petition before the Supreme Court, pleading that as I was an acting chief justice, I must get all the pensionary benefits of a chief justice, right? But then Supreme Court therein held it was listed before a two judge bench. The Supreme Court held the two judge bench held that the 23, which is a constitutional law or which is a part of constitution. So this particular thing was referred to a five judge bench, right? So whenever there will be an interpretation of constitutional law, a five judge bench or more number of judges bench will deal with that particular fact. Now, why? Now, when, like in which situation more number of judges will come? Now, suppose if we are dealing with a case of suppose land acquisition thing, and there was a judgment of five judges which was given in 1983 or something like that. Now, to overrule that particular case, obviously five judges bench in present time cannot do that, right? It will be a concurrent decision. So a more number of judges is required to deal upon that particular judgment, and the harassment judge bench will be referred by the registry, and the seven judge bench will like decide the fate of a five judge bench judgment. So likewise, this thing goes on in the constitution. Now till date, only a 13 judges bench has been set up. In the you must be knowing a famous case, Kesavananda Bharati versus State of Kerala. So in that case, a 13 judges bench was there, and like they have given a judgment by thin majority of 7:6, I guess. Yeah. So this particular hierarchy you should maintain in citing in your Moot memorial or even while citing in your oral arguments. So this particular thing you must like keep it in your mind. So also like there would be some cases wherein you will be citing foreign judgments, right? UK court cases or USA cases. Now there are many moot courts wherein I have been faced with a question that why this particular USA judgment is binding on us. Now you guys must always remember that USA or UK courts like judgments are not binding on Indian Supreme Court in any case, but they hold a persuasive value. Okay, so if a judge asks you a question that why it will be binding on us, you can say that your lordship, you can say humbly that your lordship, this particular judgment is indeed not binding upon this bench, but holds a persuasive value. Why? Because this the matter which has been dealt by USA court has not been dealt by this particular Supreme Court or any other High Court in India earlier. So we can draw jurisprudence from USA court or UK courts judgments, right? So they hold a persuasive value. So you can like answer by this by saying this. Now after like dealing with this, as I said, you can also refer to law commission's report, right? There are many law commission's report on various issues like on death penalty. There was a law commission report on section 377. Also there was a law commission report, and like there were many matters wherein you can use law commission reports. Also, you can use parliamentary debates. Like if you are dealing with a constitutionality of a particular section or an article, you can use parliamentary debates per se, because parliamentary debates will be acceptable by a court. You guys should note down that section 78 of Indian Evidence Act, they will be admissible as a public document. The proceedings of a parliament. There is a clause like in 78 it is 1C or 1D, I don't remember particularly, but in section 78 of Indian Evidence Act it is there, and you can use parliamentary debates. So all these are about your research thing. So from all these things, you can gather your wide knowledge on the particular fact sheet, and you can like know and you can outline the arguments which you can like take up in your Moot memorial and in your oral arguments. So these are all research techniques which you can use like while going with your Moot proposition. Now, after all this, okay, so now let's move to like we have 20 minutes, I guess, Raksha, right? Or I can extend it beyond that.
You can extend it if you want.
Cool. Because it is like quite a short time for me to finish everything, like researching, mooting, like Moot memorial and then oral arguments and all. I generally take 2 hours or like more than 2 hours to do it.
Okay.
But I will wrap it up like within like 1 more hour. I will.
Yes, okay.
Yeah. So let's move to Moot memorial drafting and how you can like do less number of mistakes to pave a way to winning a particular Moot winning memorial award in a Moot competition. So I will be like sharing a Moot memorial which was my best memorial in that Moot court. Just give me a minute. Yeah. So is it visible to all of you?
Yes, it is visible.
Okay, cool. So now let's deal with how to draft a Moot memorial with a less number of mistakes. Like you can be perfect in like drafting Moot memorial because it depends on judges to judges. It varies from judges to judges, and their notion of formatting and drafting and all. So for a like ideal Moot memorial, you should always remember all these things that I will be saying in couple of minutes. So the first thing is that you should always mention team code like this on the right hand side top corner of your front page of the Moot memorial. Now there are 10 segments particularly in a Moot memorial, and the first segment is this cover page. Now you guys must be thinking that why this particular cover page is in blue color, right? So most of the host institutions or national Moot courts provide you that you should always use blue color for petitioner, prosecution or plaintiff side, the party who is bringing a cause of action. Now the other party, a respondent, defendant or defense will have a Moot memorial with a cover page of a red color. Okay, so it is also important to read the rules of a particular Moot court competition which you are taking up, because there would be rules which are not similar with a Moot court that you have done previously. So every time you do a Moot court, always try to read the rules of that particular Moot court like precisely. Don't miss out any of the rules, because there are some Moot courts which will provide you that you have to keep a line spacing of 1.5. But there are some Moot courts which will say that you have to keep a line spacing of 2.0, right? So if you miss that particular thing and you make a memorial of 1.5 spacing, you will lose all of your marks, like most of your marks, right? So you have to always read the rules of the competition precisely and remember that while drafting your Moot memorial and while your oral arguments. So after mentioning your team code, like in every national Moot court, they will provide you a team code which will be your identity throughout the competition. You can disclose your name or college's name in that particular Moot court competition. The next thing that you should mention is the name of the competition, right? Suppose the name of the competition is First National Moot Court Competition 2021. So you should mention that thing in the first line, that First National Moot Court 2021. Here in you can see that I have mentioned Sri Koneru Lakshmiya Memorial Second All India Moot Court. So you have to mention the name of the competition. After that, you have to mention the forum before which this particular case has been taken up. Now, in my case, it was before the Honorable Supreme Court. So I have mentioned in the Honorable Supreme Court of Magic Land. Now you guys also should remember or take a notice of this fact that most of the Moot propositions will not give the name India in their Moot proposition. They will change it. They will give a hypothetical name, like in the like in this memorial you can see Magic Land or Indica or like Indraprastha or anything. They will give names like that. So you have to remember that particular name, and you have to use that particular name throughout the competition. You can't use in your oral rounds that in the instant case this council is appearing on behalf of uh, petitioner before this Honorable Supreme Court of India, whereas the name is Indica, right? So you can't use India in that particular sense. So you have to remember this hypothetical name throughout your like moot competition. In you should use that in your moot memorials. You should use that while arguing orally. So after mentioning this, the forum before which you will be appearing in your moot competition. Now suppose if you are appearing before a high court, so you can like mention before the Honorable High Court of Delhi, right? So depending on the moot proposition, you have to find out that. Now the next thing you should mention is the jurisdiction of that particular court. Now there are various types of jurisdiction, like you will get to know while you read jurisprudence in your like curriculum. There are many types of jurisdiction. There is original jurisdiction. Original jurisdiction means that a particular court is a court wherein a case can be brought directly, right? That is not appellate court. You can bring a case to that particular court directly. Now, original Supreme Court has original jurisdiction under Article 32. You can bring a writ jurisdiction or PI. You can file a PIL directly to the Supreme Court, right? So that is a original jurisdiction of the Honorable Supreme Court. Now there are 5 charter courts in India. There were earlier there were 3 charter courts, like established in a letters patent, which was passed by British Parliament. So there were earlier there were 3 courts that were like Kolkata, Madras, and Bombay High Court. But now it has been extended to 5 high courts. Now Delhi High Court and Allahabad High Court are also charter high courts. So the charter high courts have a benefit that they can take any case as their original jurisdiction, which can which is within their territorial jurisdiction, right? So you can file a like suit directly before a Honorable High Court of Kolkata or Delhi or like Bombay, Madras, anywhere. So that is the original jurisdiction of a particular court, wherein you can file a suit or a petition or anything directly. So now, as Article 136 deals with the appeals, the name says that special leave to appeal, right? So the Supreme Court will have appellate jurisdiction in this case. Now, in the memorial, you can see I have written civil appellate jurisdiction. As this case was a civil case, I have mentioned civil appellate jurisdiction. If it would be a criminal case, then criminal appellate jurisdiction, right? Now, many of the students ask me that from where I got this, like what would be a proper acronym for this jurisdiction thing, right? So you should note down here 2 documents which you can refer while like mooting. First one is Supreme Court's Handbook. Okay, and the second one is Supreme Court's Rules 2013. You can like easily get it in Google and refer it. Now in Supreme Court's Handbook, you can find format of every petition that can be filed before the Honorable Supreme Court of India, right? You can find the draft format of writ petition. You can find the draft format of PIL. You can find the draft format of SLP and any other suit petition or anything that can be filed before the Honorable Supreme Court. So from that document, you can know that, okay, the Supreme Court will have civil appellate jurisdiction under Article 136 of the Constitution. The Supreme Court will have original civil jurisdiction or original criminal jurisdiction if a petition is filed under Article 32. So likewise, you can find it out from the Supreme Court rules. Now then, after mentioning this jurisdiction thing, you can mention under which particular article you are invoking that jurisdiction of the court. So now in the instant case, we are using Article 136 for invoking civil appellate jurisdiction. So you have to mention that in a bracket format just below it. After that, you have to mention the case number. The thing that I have highlighted here is the case number of a particular petition or a particular case. Now, if you are filing a special leave petition which is civil in nature, it will be special leave petition bracket civil number dash. Now, moot courts don't provide you a particular number, so you have to leave this particular field blank. and then slash 2020, or whichever would be the year of filing a suit in your moot proposition. You should mention that. So in my case it was 2019, so I have mentioned this SLP bracket civil number dash 2019. Now this thing you can also get it from Supreme Court's handbook. Like what would be a proper acronym of a case name? Nowadays, like there is a trend that you will be having a moot proposition dealing with Article 139A of the Supreme Court, which is transfer of cases and clubbing up of petitions. There are many moot courts where which are using this. So in that case, if it is not provided in the Supreme Court's handbook, you can directly go to sci.gov.in, which is Supreme Court's website, and then you can click the search place for cases, the pending cases thing. Okay, then there will be a list down which will say that what are the cases, what are the case name or case acronym or case number which you can use. So there will be a long list: arbitration appeal, NGT appeal, or transfer case petition, transfer petition, or suo motu petition, SLP civil, SLP criminal. Likewise, there will be a whole list there. If you guys say, then I can show it right now, or you can find it out. It is quite easier. Like you can find it in sca.gov.in. So Raksha, do you want me to like show this to like attendees?
It is on your discretion.
Okay, so like wait, just give me a minute. I will stop this presentation. Will show you right away. sci.gov.in. Like, can you guys see this, like Honorable Supreme Court's website?
Yes, Devashish.
Okay, cool. So now you can like see this is case status, right? So you have to click on this. Now in this, you have to like wait. You have to search for case number. Okay. So on that case number thing, you will get case type. Here is case type. So while you select this, you can see this will be your acronym for your moot proposition: special leave petition, civil. There are many things like that. Review petition is there, transfer petition civil, transfer petition criminal, read petition civil, read petition criminal. Now there are suo motu, there would be moot proposition wherein the Supreme Court would have taken cases suo motu. So it would be suo motu read petition. If the case is civil, then it will be civil. If the case is criminal, then the case will be criminal. Now there are contempt petitions. Like there are so many contempt petitions going on right now. Like you have noticed that. You must have noticed that. So that would be suo motu contempt petition, civil or criminal likewise. Suo motu transfer petition is also there. So by this you can get the proper acronym of the case number that you would be using in your memorial and like while like saying in your oral argument. So just remember this thing. This is quite easier. Like it's not a rocket science. You can get it easily. Like the proper case number. After that, you have to mention the name of the parties, right? So here both the parties I have mentioned. You can mention like this in the matter of dot dot. Then the petitioner's name, Mr. XYZ versus the respondents or defendants name, right? Now you guys always should always remember that in a case of read petition or in a case of like a PIL or in a case of SLP, Union of India will always be a part of that case. Okay, you can't ignore that. So whenever you are drafting a memorial and wherein it is dealing with SLP or like read petition or PIL, you should always make Union of India or the hypothetical name Union of Magic Land a party of that particular case. Why? Because when you are dealing with a legislation which is passed by our Union Parliament, you have to make Union of India a party. Obvious thing is that. Now, if you are filing a public interest litigation, now it is concerning general public, and the rights of general public should be guarded by Union of India, obviously. So that's why in that case also Union of India will be a party. So you shouldn't forget to mention Union of India is a party if you are dealing with a SLP or REIT or PIL. Okay, so just like notice this particular thing and remember it. Like I will say you an instance, like in one of my moot court, the other we were dealing with SLP in this moot court only. Yeah. So the other party have not mentioned Union of Magic Land. They have mentioned the other parties, the girl's name in this case, as the private party, and they have not mentioned Union of Magic Land. And in this case, we are dealing with the constitutional validity of polygamy, right? So that is a decision which can be taken by Union of India only. Now, if you are not making Union of India a party, how you will deal with this particular thing, constitutionality of polygamy, right? So I have taken this particular point in rebuttal that the opposite party have not mentioned Union of Magic Land or have not like made a party to Union of Magic Land. That's why the opposite party cannot argue in this particular thing that whether polygamy will be constitutional or not. Okay, so now you like might have got the relation between why you should mention Union of like Magic Land or India, whatever would be the hypothetical name in your mood proposition. Thereafter, you can mention the disputes concerning in your particular mood proposition. As in my case, it was the right of a Muslim wife to procreate children and all. It was there, you can see. So if your case is dealing with the arbitrability of a fraud, so you can mention that dispute relating to arbitrability of a fraud happened in a contract or anything, any matter that is like any important thing that is relating to your mood proposition in a keyword, in a shorter form, so that the judge who sees your memorial and from the first page he will know that okay, these are the issues before me, and this party will be both the parties will be dealing with these disputes or these issues. So you can mention that. After that, you should mention the before whom you will be appearing. So obviously, when you file a petition before the Supreme Court, you will presume that it will be before Chief Justice of India or Chief Justice of Magic Land in this case. So you have to mention to the Honorable Chief Justice of Magic Land and his companion justices of the Honorable Supreme Court of Magic Land. Right. So you have to like mention this whole phrase. Like you can copy paste this thing from the memorials. Okay. After that, the another thing that you should mention is the party on whose behalf you are appearing. Now, if you are appearing on behalf of petitioner, you should mention memorandum on behalf of petitioner. Now, if you are like representing respondent, you should mention memorandum on behalf of respondent. So you have to mention the party whom you are representing in the end of your cover page. Right. So that is all about your cover page thing. Now the next important thing is table of contents. Now table of contents will be like including all the segments of your moot memorial, right? Like if you have read any book or novel, you will see that there would be a table of contents stating different things or different chapters that is mentioned in that particular book. So likewise, this particular table of contents plays that similar role for your memorial, which will contain all the segments that you have mentioned in the memorial, like index of authorities, statement of jurisdiction, arguments advanced, prayer, anything that you have mentioned in your memorial as a heading part that will contain in table of contents. Now, there is a easy procedure for this making table of contents in Word file, like in the MS Office, right? If you go to references section in MS Word, you will find in the left side that there will be a bar stating table of contents thing. Okay. Now you just while you like mentioning the headings in your memorial, you just select that particular thing and select heading thing. There will be a heading bar. Just select it, and every heading that you mention, you select that particular thing and click heading option. So after doing that, while you go to table of contents, just mention develop the table. So the Word will automatically make this whole table of contents for you with the accurate page numbers. So you don't have to like do the hard work of copy pasting each and every section again and again to the front, to the second page, and then mention the page number. That will be a hectic thing. So you can use this feature of MS Office. You can also like Google it and find it in YouTube, like how to use table of contents feature in MS Office, right? So by that way, you can make your table of contents easily. Now you can see that in each page, I have mentioned the name of the competition, right, in the above, in the header part. So you can also like do this, mention, this is a standard form. So you can mention the name of the competition, and then in the footer part, you should mention the party whom you are representing again, and then the page number of that particular page, right? So these things will continue till end of your memorial. So you should always remember that these are ideal things which you can like remember and use in your memorial for like winning a best memorial award or like that, or fetching good marks in your memorial, because memorial marks plays an important role in winning a moot competition. Like in one of my moot course, I have scored 0.5 marks lesser than the another semi-finalist who was against me, who was put up against me. So I lost that round because of that particular 0.5 marks of memorial. Because both the teams, my team and that opposite team, had like equal mark, 93 marks in our oral rounds. But due to this 0.5 marks of difference, I couldn't go to final. So like you can like imagine the importance of memorial marks and 0.5 marks, which can play a role in winning and losing the particular mode competition. So you should always make your memorials seriously. Now after this table of contents, the next important thing is a list of abbreviations, right? So in the list of abbreviations, you have to mention all the abbreviations that you have used in your memorial, and also like mention their expansions. Now while saying this, you should always remember that this particular list of abbreviation should always be in a tabular form. Okay, you shall not mention like parallel lines or something like that. You should always mention this in a tabular form, so that it will be a representable to the person who is like judging your memorial, or the person who will see it while your oral arguments. So you should always mention this in a tabular form. Now one question that must be coming to your mind, that how do you know this ART dot means article, or this PARA dot means paragraph, or this ORS dot means others, or like CAL dot means Calcutta High Court, right? So these all things you can find in Google, like in the first hand you can find it in Google. Now if you are dealing with a criminal case, or if you have any commentary on a criminal law, like big book practitioner edition, suppose R&D's practitioner edition, or like DD Vasu or Nelson, you will just like after going like after turning few pages, you will see that there will be a list of abbreviations provided in those commentaries also. Even you can find that in Categor or SN Mishra, like the student editions also. So from that you can like search for a particular abbreviation, and you can find the expansion of that particular abbreviation. Okay, so now if KL, you don't know what is KL dot means, so you can just go to R&D and see where C part is coming. That will be in alphabetical nature, no? So A, B, C, D. When C comes, you can see CAL dot means Calcutta High Court. So now you can use that in your memorial while like writing down your expansions part. So likewise, you can find the expansions, full like correct expansions of your abbreviations. Now after that, the next important thing is your table of authorities or index of authorities, like some competitions say. So table of authorities will contain all the case laws that you have mentioned in your like Moot memorial, all the books that you have cited or referred to, all the reports. As I have said in the beginning, that there are so many reports which you can refer. Even reports are there. There are NGO reports, independent NGO reports like Amnesty International's report, or HRLN's Human Rights Law Network's report, NCRB's report, or any other report. So you can any other treaties you can mention in that in this particular table of authorities thing. Also, you can mention the list of websites that you have used while like researching for this Moot competition. So obviously SCC Online, sci.gov.in, judice.nic.in, manupatra.com, Westlaw, and online. There are so many websites like which you can use while researching. So you can mention that. Likewise, you can see here there are a list of Indian cases. I generally do, if I like use foreign cases or US cases or UK cases, I divide my table of authorities in two parts: list of Indian cases, then again list of foreign cases, or if there are substantial amount of UK and US case, then another two tables: list of USA, list of cases of USA courts, or list of cases of UK courts. Right? You will see that there will be a table of list of, yeah, it is there, list of foreign decisions. Right? So likewise, you can divide this particular thing of list of cases. After that, you can mention the list of statutes. As I have said in the beginning, that you have to refer to the statutes which are like in concurrence with your moot proposition. Suppose you are dealing with the constitutional moot proposition, as I said, and farmer said. So you can mention the Constitution of India 1950, the Farmer Act Amendment Act 2021, or something like that. So you have to mention all the statutes that you have referred while researching and framing your memorial. After that, you have to mention list of books that you have like referred to while researching. Now, for constitutional law, you can refer D.D. Basu, Arvind Vidatar's book is there, Jain Pandey is there. There are like so many books. MP Jain is there, V.N. Sukla is there. So like you can cite all these books. Now if you are dealing with IPC, as I said, you can mention Kedikor, you can mention R&D, you can mention again D.D. Basu, you can mention Nelson's. So you have to mention all the books that you are like you will be using in your moot court, like preparation of your moot court. Now obviously I have not read all the books that I have mentioned, like 1920 books for this moot competition, but for like fetching an impression mark, I have mentioned all these books, as I had a list of these books from my like previous moot courts. So depending on the page numbers, restriction of page numbers, you can extend the list or reduce the list. Okay. So list of books cited. Yes. So I have also mentioned a list of international treaties and agreements which I have used in my moot memorial. So in this format, you can also mention any of the treaties, any of the conventions, any of the UN reports that you would be using in your moot, like while framing your moot memorial. Then yes, the list of reports is also there. Then a list of online databases that I have used, I have mentioned that. So these all were the parts of your table of authorities or index of authorities, right? After that, then next thing is statement of jurisdiction. Now I would say from my experience is that statement of jurisdiction is the most vital part of the moot memorial, because if you mention a wrong jurisdiction, wrong article, or wrong section in this particular section, you will face a huge grilling from the panel of judges, and even you will like get a bad impression mark from the bench while oral arguments. You will face the rebuttal of the opposite party. Like there are a lot of negative consequences of mentioning a wrong jurisdiction of that particular court, depending on your moot proposition. Now suppose your case is under Article 136, but you are mentioning Article 32. So obviously that thing is wrong, and you will face huge grilling on that particular thing. You have to justify why Article 32 will come into picture. The judges will like grill you like anything. So you should always remember that, and always research more. Always invest your time while like finding out the jurisdiction of that particular court. Like this particular statement of jurisdiction is of 4 lines, but it is like quite a vital thing which you guys should always remember while researching. Now the statement of jurisdiction part, you can like directly mention this, that the petitioner have the honor to submit before the Honorable Supreme Court of Magic Land the memorandum for the petitioner under Article 136, specially petition the Constitution of India, like this. I will share this memorial with Raksha, and like she can forward it within your group, and you guys can refer it for your future moves. After that, you should mention the particular article or section that you are referring in the statement of jurisdiction, and elaborate it. Just copy paste the exact thing that is there in the statute, right? So I have like copy pasted whole Article 136 here. Now suppose you are appearing before a high court and you have gone in an appeal, Article 372, yes, section 372. So you can directly like copy paste section 372 in its entirety. Right. After that, you can mention the present memorandum, set forth the facts, contentions, and arguments in the present case. Right. So this would be your statement of jurisdiction in a presentable manner. So always remember that to mention a accurate, exact, and correct section or article in your statement of jurisdiction. Never ever mistake that. Now I have also seen moot courts wherein a statement of jurisdiction contain 10-20 marks in the total number of segments for marking your memorial thing. So if you just mention a wrong article, you will lose 20 marks in a straight manner. So that will be a huge loss for your team. So always remember to mention this jurisdiction thing accurately and the correct one. Also, you must have noticed that I have mentioned the Constitution of Magicland is perimeter to the Constitution of India, right? This is obvious thing. The rules of the competition say that, but you can also mention this like for fetching an impression mark from the judges. The Constitution of this is perimeter with Constitution of India, right? Now the next thing is statement of facts. Now most of like I have checked many like a number of memorials of various moot court competitions wherein I have seen that the teams directly copy paste the facts in the statement of facts. I will say that don't do that because that statement of facts also carry some mark in your memorial marking thing. So always narrate the particular fact sheet in this statement of facts in your own words. Just try to take some segments, some lines or some paragraphs, but don't copy paste it directly. It will look too odd and it will make you in a loser position. You can also like divide your statement of facts in headings, which like creates a more impression on a person who is judging your memorial, right? So you can like mention, you can divide your whole fact sheet in like different segments. First one is background, then what all happened in that particular case. Like if it is a criminal case, background of the accused, the happening, the date of the incident, the investigation part, the trial part, and then appeal part, and all these things. So you have to like think of a particular phrase for giving it in your heading in your statement of facts. So if you divide your facts in heading sections, then like it will fetch more impression of a judge. And again, it will be easier for the person who will be seeing your memorial for first time in the oral rounds, right? So it will make things easier for you. Now, after statement of facts, the next part is issues raised or statement of issues. Right, as I have said, there are two facts, disputed facts and undisputed facts. Right. So the disputed facts will comprise of, will make your issues. Now, while reading down a particular fact sheet, you will see that there are a number of disputed facts. Like suppose, like I'm giving you an example, like there is a acid attack case, right? Mr. X going in an auto, throw acid in a glass bottle, throw hydrochloric acid in a glass bottle on Miss Y, and Miss Y was injured. That particular incident happened on 12/1/2021. Now this is a short fact I have said. Now the disputed facts, now the undisputed fact is that there was a acid attack incident happened on Miss Y, right? That obviously both the parties will accept it in a case. But the question is that whether Mr. X has used this particular acid on Miss Y, whether Mr. X has used hydrochloric acid or any other acid on Miss Y, whether Mr. X was present on the date of the incident in that auto on that place. So this all will be your disputed facts, right? Now always remember that there would be many disputed facts in your moot proposition, but don't make all the disputed facts into your issues in a moot proposition, right? So you have to make a larger heading and under the umbrella of which you can like keep all the small disputed facts in as a part of your sub issues. Now suppose if your issue is that the main issue would be whether Mr. X has committed a crime of acid attack. So that would be your main issue, right? Under the umbrella of which you can mention that yes, Mr. X was present on the date of the incident on that place. Mr. X was traveling in the auto of this person. Mr. X has used this bottle and hydrochloric acid on Miss Y. So this would be your sub issues. Likewise, you can like turn arguments for both the parties, from prosecution or petitioner part or from defense or defendant part. So likewise, you have to uh, find out a particular broad issue which you can take up and make a elaborate argument on that, and can use and can like put in sub issues for that, for presenting it in your arguments advanced. Now there are two types of issues you must remember. First one is preliminary issue, and then second one is your issues on merits. Now the preliminary issue is a part which deals with the maintainability of a case, right? Uh, you can see, yeah, here it is there. This one is your preliminary issue, as I said, which deals with maintainability part, right? So it would be whether the special leave petition, if you are dealing with read petition, then whether the read petition is in the instant case is maintainable before the honorable Supreme Court or not. So that would be your preliminary issue. Now the next thing, issue on merits would be whether, as I said, whether Mr. X has committed the acid attack, whether the prosecution has proved the case beyond reasonable doubt, right? So all these things would be your issues on merits. Now after finding out your issues, you can like correlate it and make your arguments in consonance with your facts. So now after issues raised, the next thing is summary of arguments. Now summary of arguments is the most ignored part of a moot memorial, because students like tend to do directly copy paste from arguments advanced in this particular summary of arguments section. But I would suggest that don't do that, because that will fetch a negative impression for the person who will be judging your moot memorial. So always like try to convert the whole argument advanced part in your own words for a particular issue, and then write it down like in your own words in the summary of arguments section. We generally do this summary of arguments after we have like prepared the arguments advanced. This is the last thing we do like while preparing our moot memorial. So you should narrate this particular part in your own words. Now suppose, like as I said, the first issue is relating to the maintainability of case. Now you can mention simply, you can mention in your summary of arguments that the instant appeal is maintainable before the Supreme Court, because the petitioner has a locus standi in the instant case, because the judgment of the High Court is appealable. The instant case deals with a substantial question of law. The matter concerns the general public importance. Likewise, like if it is a read petition, then again you can mention the petitioner has locus standi. There is an infringement of the fundamental rights of public. Then the violation relates to the general public, and likewise. So you can divide it into your sub issues and the subsets of that particular issue. So you should mention that in your summary of arguments, which will give an impression to the judge that okay, this particular guy or this particular team is dealing with all these things, and which is covering the whole issue in toto. So it will fetch an impression mark for you. Again, there are some moot courts where you will see that there would be 80 teams, 90 teams participating in that moot court. So obviously the judge wouldn't have like much time to check both the memorials for a team. Okay, so the guy will just read your summary of arguments and apprehend that okay, this particular team is covering this set of things in a particular issue, and which is like contending and which is accurate and perfect. So I will mark this particular memorial with the highest mark. So you should never ignore your summary of arguments part, because sometimes it would be crucial for your marking thing in your competition. So after summary of arguments, there is a written submissions or arguments advanced part of a memorial. Now, as you all know, this part will contain everything, all of your research, all the facts, all the rules, all the case laws, all your arguments and everything. So this is the most crucial part of your moot memorial, which you should draft you should draft it with in a proper manner and like sincerely. You shouldn't do any mistakes in this part, because if you write a wrong argument for petitioner, then obviously the opposite party will take that in rebuttal and he will fetch like a +1 point against you. So you should always proofread your arguments advanced part and see that if you are not committing any mistake in this particular section. Now there is a rule that we generally follow for drafting your arguments advanced or for your oral arguments. That is IRAC rule. right? You can like note down that IRAC rule. Now I in IRAC rule stands for issues. R stands for rules. A stands for assessment of facts, and C stands for conclusion. Right. So in this particular hierarchy, you have to draft your argument, or you have to prepare your like speech for your oral argument. Right. So you have found issues of that particular case. So you here you can see that I have mentioned the issue. What is the particular issue in the instant case? Right. After that, you have to mention the rule. Rule will contain like your statute, the decisions that you have found in your favor. So you have to mention both the things in the rules part after that. So now, can anybody from you say that whether the judgments of the Supreme Court can be said a law or a rule? Raksha again, like.
I think it can be used according to Article 13.
Okay, article, yes, your answer is partly correct, but there is a major article which says that the judgments of the Supreme Court is a law, and that is Article 141. So it will be Article 141 read with Article 30. So always remember that the judgments of the Honorable Supreme Court is a law of the land, are a law of the land. Okay. So after mentioning the what are the decisions, the number of decisions or the decisions which are squarely similar with the facts of your case in this arguments advance or written submissions part, you have to assess that particular rule with the facts of your case. Now suppose I am using Lakshmi versus Union of India, which has given guidelines for acid attack, right? So what is its like relation with the facts of my case? Now that judgment has given laid down a number of guidelines, like you cannot buy acid without any prescription or authorization from any shop. Any shop cannot the shop which is dealing with acids cannot sell you without any prescription, and there were so many guidelines. So I have to relate that particular guidelines or relate the particular part of the judgment, ratio decidendi part, which we generally say the binding thing of a particular judgment, and then assess it with the facts of the case, like how it is coherent with the facts of the case, and describe that in a particular manner. After that, you have to mention the conclusion part after using issue, and then the rules, and then the decisions of the court, and the facts of the case. You have to like conclude the whole issue, that in the light of in the light of the decision above stated or aforementioned and the facts of the case, the instant writ petition is maintainable, or the instant specially petition is maintainable, right? So you have to always give a conclusion at the end of each issue. Now I have seen many moot courts wherein people have given hundred of cases in a issue, but they have not set the assessment of those decisions with the facts of the case, or they have not given the conclusion. So now how the person who is checking the memorial or memorial checker will get to know that what the team is mentioning, or what the team is trying to connect these judgments with the facts. So that would create a negative impression. Now always remember that there is no particular limit for mentioning your cases in a memorial, but whenever you mention a case, try to read that particular case thoroughly, try to remember the facts of that case, the number of judges or the quorum of that particular case, and who were presiding that case. The case was decided on which date, and what was the exact ratio decidenti or order or direction part in that particular judgment. So you should always remember those things, because judges tend to ask you randomly. They will ask that, Madam Counsel, at page number 10 of your moot memorial, at footnote number 62, you have mentioned Mr. X versus Mr. Z. So what was the facts of that case? Now, if you have used that particular case and you don't know the facts of the case, or you don't know about that case, that will again create a negative impression against you. So always try to remember that. Now, if you are using 10 cases, but all the 10 cases are relevant and all the 10 cases are directly in connection with your facts, and you can use like you are able to use those 10 cases to satisfy the court on behalf of your point, then that will suffice the cause. Like those 10 cases will be on higher pedestal than the number of like 100 cases that the opposite party is citing without like assessing those cases with the facts of the case. So always remember this particular thing. Now the next thing is that you can see there are citations, right? So now while to know about the citations, you have to read the rules of the competitions again with like carefully. There are many competitions which say that you have to follow the citation format of 20th edition Blue Book. So now you should know that how the 20th edition citation format looks like, or 19th edition citation format of Blue Book looks like. So you can get that from YouTube directly, or you can Google it simply. Blue Book 20th edition citation format or authority citation format. It will show you the results, like results, and then you can use it in your memorial. Now in this case, I have used 20th edition format, which like looks like this. Your case, the first name would be non-italic, then V will be italic, then again the next party name will be non-italic, and then the citation will be non-italic. So this is the 20th edition format. Now in the 19th edition, the whole name Mr. X versus Mr. Z was in italic format, and only the citation was non-italic. Right. So you should know these distinctions between 19th edition, 20th edition, and now 21st edition has also come. So you should know that. Now again, while citing the cases, you should always try to like mention paragraph number of that particular case, like which para you are referring to. In this moot court, I haven't done, but all the moot courts that I have done afterwards, I have tried to mention the exact para that I am using. Now, suppose if I have said that SP Gupta versus Union of India, then always try to mention the para that you are using in your moot memorial. Suppose para number 4. So you can just use para symbol and then mention 4 after the citation thing, right? So that will increase your authenticity of research. That will give an impression to the judge that okay, this person has read the judgment carefully, and after that this team has got para number 4 which is in his favor, or which is against the respondent, or which is against the opposite party, right? So which will this will increase the authenticity of your memorial and your research thing. So always try to mention that para number, whichever case, like you won't find para number for all the cases that you mentioned, but try to find out the para number of maximum cases, right? Because I have seen that in the recent moot court in which I have taken part, I have mentioned para number of all the cases that I have cited, and that was a like best memorial for that competition. There were 200 teams participating in that. So you can see that how that para number thing can bring you more marks for your memorials. Now after this, you can see that I have divided this particular first issue into sub issues, right? 1.1, 1.2, and there would be 1.2 divided into further sub issues. 1.2.3, 1.2.2, right? So many of you might be thinking that how I have got these sub issues, right? As earlier I have said that you have to read the statute thoroughly. Now while reading the statute, you will get the ingredients of that particular article or section, right? Now suppose if you are dealing with this SLP, as I said, you will obviously find that SL 136 in the constitution is mentioning that SLP can be entertained when there would be a substantial question of law, right? So you can use that as a sub issue in your memorial, that in the instant case there is a substantial question of law, or there are substantial questions of law, right? So likewise, you have to read the whole article, that those things were derived by the Supreme Court decisions. So while reading a commentary, you will obviously get all those other in your sub issues thing. So likewise, while reading your commentary or statute, you should read them carefully, as I have earlier said, so that it will again create an impression that the team has done an in-depth increase your chances of winning a moot memorial, winning a best moot court memorial. Now, this is all about your arguments, advanced thing. After, in the end, it would be prayer. Now, the prayer is the last section of your memorial, but is the most crucial thing again, I would say, because there are many moot courts wherein I have faced a huge grilling for writing down a wrong prayer. Right. So you must always remember that in prayer section, you should always state the specific thing or specific relief that you are claiming. You shouldn't make the prayers open-ended, because those things will attract grilling from the judges or from the bench, right? Suppose you are dealing with a moot proposition containing Article 32 of the Constitution, public interest litigation, right? So obviously you will you will pray for invoking a writ jurisdiction, right? Now most of the teams after writing this particular phrase, wherefore in the light of this and declare that the present instant writ petition is maintainable, but they don't say that which writ petition you are asking this court to invoke, right? There are five writs, no? Habeas corpus, then quo warranto, mandamus, all these things are there. So you have to specifically mention in the next subsequent prayer, after saying that this instant writ petition is maintainable, you should always mention that this honorable declare that the writ of mandamus is issued against the Union of India for doing this particular thing, for removing or for declaring section 377 unconstitutional, or whatever maybe your prayer as per your moot proposition. So always try to mention the specific relief that you are asking, or that you are praying before the court. Now if you are dealing with a civil case, suppose infringement of patent, then you should always seek for the exact damages that you are claiming. People say that this honorable court may graciously be pleased to declare damages, or direct a respondent to give damages, but how much? If you are not mentioning this, then you will obviously face grilling from the bench. So you should always mention in the subsequent part that the damages of 2 crores or 200 crores, whatever you compute as per your moot proposition. So you should always, as I said, mention the specific things or specific prayers that you are that you want to put forth before the bench. Now after that, this or to grant any other, this is the basic format that everyone uses for drafting a moot memorial. So you can directly copy paste this thing. Then you should always mention the place where the court or the cause of action has happened. Now then the date on which you are filing. The date would obviously be the first date of the moot court competition, on the date on which you will be having your preliminary rounds, right? So you should mention the dates, and after that you just mention just give a symbol of electronic signature SD thing, and then counsels on behalf of the petitioner, or if you are representing respondent defendant, then counsels on behalf of the defendant, right? So all these things will be your technicalities for drafting a proper moot court memorial. Now there are few things that I will say for preparing your oral arguments or writing your oral speech. As I said, you have to prepare your speech in a brief manner, because you want to get much time in your moot court competitions. They will give you 10 minutes or 5 minutes to speak, and you have to prepare your whole speech in a brief manner, which will obviously include all the important points that you want to mention before the court, and take all the things in your favor or satisfy the court on that particular issue, right? So what I do is that I take a A4 size paper, fold it, and then on both the sides I write down all the bullet points. Issue number one is relating to SLP maintainability, then locus standi, then substantial question of law, then the general public importance. All these keywords will help you serially give your oral argument before the bench. So you can use this bullet points style while preparing your this oral round speech. Then again, if you are mentioning any case law, you have to see that if a two judge bench is sitting there, then you have to always mention it two judge bench decision, or a decision which is higher than that, three judge bench decision or five judges bench decision, right? So don't ever mention one judge's bench decision, because that will be discarded by the court, obviously, because that is not binding on a two judges bench or a division bench, right? And also you should remember, also you can mention in the side that quorum number is 3 or quorum number is 2, the number of judges. Quorum means the number of judges who have decided that particular case. So you can mention that, and just mention two. If there is a five judge bench, then just mention two judges name. Suppose uh, Deepak Mishra CJI, then DY Chandrachud judge, and others. So just remember the judges name, because the in depending on the moot courts, judges ask that who were the judges in that case, when that case was delivered, what were the issues in that case, what were the facts in that case, right? What was the bench strength. So while making your bullet points, and if you are citing a case, just mention these things in the side of that case, so that it will come to your eyes easily, and you can instantly mention that, which will obviously fetch impression for you. And the court will notice that, okay, this guy is properly prepared for arguments and all thing, and you will obviously get much more marks than your other counterparts. So this thing is there for oral arguments. Now there is a proper format of how you should go with your oral rounds, right? Now firstly, when I am talking about the physical part, now both the parties will be sitting in the middle, judges will be sitting. So if you are representing petitioner, now everyone is sitting and court master is not saying you to start your speech, right? So speaker one will just stand and take permission from the court, that the council seeks permission to to the dais or reach to the podium, right? And then you bow down if the judge agrees and say much obliged, right? You cannot use thank you or or any other word while presenting yourself in your moot court. So you have to always use much obliged or highly obliged phrases while if a judge agrees to your request or agrees to your any prayer or thing, just say much obliged and bow down, or highly obliged and bow down. After that thing, you reach to a podium and again wait for the indication of judges. If judges are busy in talking within them, then again seek permission from them that this council would request your lordships. This council would request your lordships to start with the submissions that this council has. Right. Obviously, then the court will pay attention on you and give permission. Then again, you have to go down and say much obliged or highly obliged. Then you take you start by saying that in the instant case, the speaker one is appearing on behalf of the petitioner, in the case of Mr. X versus Mr. Z. And after saying that, you take permission for stating the statement of jurisdiction, right? In the thereafter, you have to take permission, like your lordship, the council seeks permission to move to the statement of jurisdiction or state the statement of jurisdiction. So obviously, then the court will give you permission. Then you have to again go down and say much obliged. So you have to say your whole thing in a humblest manner. You won't be you won't be Sunil, what I say, Sunil Sethi, or who was that Tariq pe Tariq thing. You can say that. Okay, that was the moot court things don't work like movies. So you have to be the humblest person in the courtroom. After that, you move to statement of facts. Now, in most of the moot courts, they don't ask you for stating statement of facts, but you should always prepare prepare all the important things of your fact sheet. Like it should be, you should complete whole thing in 30 seconds, right? That is the ideal time, or else you will lose all your time from arguments part. Like if you are having 10 minutes, you will lose 1 minute or 2 minutes for just stating facts. That is a loss for you. So always prepare that or remember that in bullet points and state that within 30 seconds. If judges say that, you have to say the facts. After stating the facts, you have to again take permission for stating statement of issues. Now, while saying statement of issues, the speaker one should always mention whole the total number of issues. Like the issue number 1 before this honorable court is this, issue number 2 is this, issue number 3 is this, issue number 4 is this. However, this present council will deal with issue number 1 and issue number 2, and this council's co-council will deal with issue number 3 and 4. While saying that, the speaker 2 will stand and bow down, okay, and then again sit in his place. After that, you take permission for starting your arguments. And then much obliged thing and all. Then after that, you state issue number 1 is this. It is the humble submission of the petitioner that the instant specially petition is maintainable before this honorable court, because the petitioner has requested locus standi. The petitioner, the instant case is having substantial questions of law. The matter is concerning general public importance, and all those arguments that you have prepared, and say it briefly. Okay. Now I have seen in many more courts, speakers say it like a bullet train. They will finish up everything, and judges couldn't understand it anything. So you have to say it in a you can speak. You should speak it fluently, but in a proper pace. You shouldn't be too fast or too slow. So you have to maintain a proper pace. You have to see that if judges are understanding anything or not, if judges are feeling boring or not. So you have to change your tone. You have to change your way like that. So you have to use your presence of mind while arguing orally. Now I have seen many moot courts where the judges will not let you say anything that you have prepared for arguments. They will start grilling from the first hand. They will start grilling you. They won't let you answer anything. Like I have even faced that situation. But the merit of that situation is that if you give all the answers correctly, if you satisfy the court on all its queries, you will obviously score highly, right? I will say a situation in Heat International Moot I have participated, wherein in the first round, judges didn't ask me anything. They were silent spectator. They heard everything. They gave me 63 marks. Now in the second preliminary round, when I when I went for oral round, the judge started. I haven't kept my papers. He started grilling me with the first question. I was like, what is this? I haven't kept my papers and memorials and compendium anything, and he is questioning me like that. And luckily, I have satisfied all the queries. He didn't allow me to say anything. So that is the trick. They will grill you. You have to put your arguments. You have to put your case laws in between that to satisfy the court on all his queries, so that your all arguments will be covered and the court's queries will be satisfied. And in that round, I have scored 98. So see the difference. The silent spectator judges will never give you marks. But the guy who is questioning you and grilling you like anything, and if you satisfy him, he will give scores in high manner. Out of 100, he can give even 100 out of 100. So you have to remember that. You have to take that positively, and you shouldn't be irritated कि क्या बोल रहा है ये खाली grill कर रहा है मुझे. He is asking questions again and again. He is not letting me speak what I have prepared. He is not letting me cite compendium. So don't get irritated. That is a positive thing for you, right? So always take that thing, grilling thing positively for you. Now after this, always remember to state your prayer, right? After completing your arguments, if first speaker have completed, then say the judges, say the bench that if your lordships are satisfied with the arguments stated by this council number 1, then this council would like your lordship to call upon speaker number 2 to deal with issue number 3 and 4, and then leave the podium by saying that it was an honor arguing before your lordships, and then go down and then come and sit at your place. Then the speaker 2 will follow up, and the speaker 2 will say the same thing. If your lordships the council seeks permission to begin with the arguments, then he will start with issue number 3, issue number 4, and after completing everything and all, he will say that if your lordships are satisfied, then the council would like to move to the prayer. Then while saying the prayer, all the 3 members, the speaker 1, speaker 2 is obviously standing there in the podium. Speaker 1 and researcher still stand. They shall not. They shouldn't sit and see that. See like that. While speaker 2 is giving prayers or saying prayer, all other members, researcher and speaker 1, should stand. And after completion of the prayer, all 3 members should go down, and then the speaker 2 will obviously come back to its place. Now, another important thing is that all the three members should hear the arguments of opposite party carefully, because there is a rebuttal round in every moot court, right? So you have to again counter all the arguments in a like brief manner, in a short time, of the opposite party. So you should carefully hear all the arguments that the opposite party is doing, and write it down in bullet points, 1 2 3 4 points, and then again speaker one or speaker two, that depends on your team's like discussion and decision, and then he will go and say its rebuttal things, rebuttal points. Okay. So after completion of your part, don't talk between each other कि कैसा गया मेरा, अच्छा नहीं गया, ये हुआ वो हुआ, जज ऐसा कर दिया, वो सब मतलब don't go into those things. Always remember, always try to concentrate on the arguments of the opposite party. Okay. So this was all about your oral rounds. I will send a PPT and my memorial. That PPT will be containing all the proper phrases that you should mention in your oral rounds, and you guys can use that like in your. You guys should remember that thing, and then you can use it in your further like moot courts. And I will also send Raksha the memorial, that like I have won the best memorial thing. Then you guys can also take references from those memorial, and take like inspiration. You can take inspiration from that. So yeah. So that was all about the session. It was quite long, I guess. It is 5:44 now. So there are a few like members, they have left also. So yeah. So that's all for this like mood session. And also you guys should always like keep your enthusiasm at top. You should always be energetic to take part in a moot court competition. I have seen my classmates who have done one moot court. They have faced failure and they didn't do a moot court till their 5th year. So don't do that. That doesn't make any point of doing your first moot event, right? So always keep doing moot courts consistently. If you are facing a failure, then take inspiration from that. Take down all the negative points, all the things that you have done a mistake in that, and like convert it into a positive thing. And again, participate in the next moot court with all the bang and all your arrows and all things, right? So don't stop after like facing a failure in your first moot or second moot. Don't get irritated, as I said. So you have to keep your enthusiasm, positivity, and energy with you always throughout your 5 years, throughout all of your like all these 5 years. By that only you will like succeed in this particular moot court thing. Yeah. So that's all for today's session. Raksha, you can like take over the mic.
Mohini, you can ask the questions.
No. First of all, Debashish, thank you so much for enlightening us on the much needed topic. And okay, if any participants would like to ask any question, please unmute your mic and switch on your video if it may deem fit, or else you can write the questions in the chat box. I will ask my question. Okay, yeah. Actually, I have a question from my last experience. Actually, I participated in XYZ National Moot Court competition, and it was my first time. So I thought that the judge will ask me a question. Judge will ask me question one by one. But I was bombarded with so many lot of questions, and I didn't understand how to tackle the situation. And I think you answered it well. And I just want to ask you, the thing is how to maintain your calm posture. Actually, my calm posture was abducted in some way, and I didn't know how to tackle it. So I want you to give some tips about it.
Okay, now what I follow with my team is that I grill the speaker. I like if I am a researcher, then I grill both speaker one and speaker two like thoroughly. I will ask all the basic questions. I will ask all the important questions, and I take that session 2-3 times so that both the speakers are well aware with the questions that may come by the bench in the moot court, and by this practicing thing, they will keep their demeanor and they will be calm throughout the moot. So you have to practice that with your teammates. Now, if I am speaker, then I in our college there is no moot court society, or there are no seniors who can guide me or my team for this moot court. So I ask help from NLUO students. In Odisha, there is NLUO, or students from KIT, pass out students from KIT, and I ask them, and I like arrange a session, and they grill me. They grill my team if I am the speaker. So by practicing 2, 3, 4 sessions, and you will be obviously be prepared for all the questions and what would be the probable answers. If you don't know the answer in the first session, you will obviously research on that gray area parts and come up with the answer in the next round. So by that thing only you can do this. You must have seen that NLU students, they were like they would be calm like ice, but would be fluent in their arguments and would be like a fluid. They will speak. So all that thing come from practice. They will be giving their session in domestic rounds. Again, they will face 2, 3 grillings in their college. Again, they will face grilling from their seniors and faculties. And if the college is quite prominent, like I have seen in RML Lucknow, they call judges from High Court, Allahabad High Court to grill them again. So you see the preparation thing. So how much they prepare for their oral rounds only. So by that only you can like tackle questions. Now again, as you said, the judge bombarded you with a number of questions. That is also a tactic of a judge to see that whether the speaker is remembering all the questions and answering that. Even once I have faced Gautam Bhatia, who is a constitutional law expert. You can search about him. He bombarded me with 10 questions on that first issue. It was Article 32 or something. So in that case, there comes a role of researcher. He has to write all the questions serially and quickly and just pass on that sheet to the court master and he will give to the speaker. By that, you will have a list of all the questions and you can, by seeing that, you can answer all the questions if you have answer. If you don't have answer, then again, like just see the researcher if he gets the indication. That is why I said there must be compatibility within all three of you. Either speaker who is sitting there or researcher will again write down the answer in keywords and give it to you and you can then further answer to the judge. So you have to make the strategy within three of you and like there must be compatibility or else like it will be a difficult. I have seen situation where my researcher would be sitting and I was asking, "अरे compendium से पता कौन सा जज था?" So वो बैठा हुआ है like कुछ भी नहीं बोल पाया. तो फिर I went to the bench where like we all three were sitting. Compendium लेके आया, then I checked it. So yeah. So all three would be should be on same page. All three should be enthusiastic for winning the moot. So yeah, this thing. Any other query?
This Paul, you can continue.
Yeah, my name is Paulami. I had a follow-up question to Mohini's. Even my personal experience was my first moot in my college, and I was also bombarded with questions. And I think first thing was I blanked out completely, and second thing is there were questions which I didn't know the answer. So in those situations, should I try to answer them or is it better to say my apologies?
As I said, your researchers should be well versed with all the facts and all the arguments, all the things that is there in your memorial, all the things that is there in your compendium. So if researcher fails to answer or the other speaker fails to answer you in the cheat format or anything, then you should beg your pardon. You should say that apologies, the counsel is unaware of the query that the bench is posing to this counsel, and just accept that you don't know this. Don't bluff anything. Like if a judge asks you ingredients of Article 136, you would be saying ingredients of appeal, Article 134. That wouldn't work, right? So don't bluff. That will create a negative impression. Instead of that, if you don't know, if you are not getting answer from your teammates, then apologies. Just beg pardon to the bench.
Yeah, okay. I had a question.
Yeah, ask me.
Yeah. So sometimes what happened in my first moot that I participated is that I ran out of time while I was just giving my whole submission, and as I was the second speaker, I had to complete with the prayer as well. So the allotted time was 5 minutes, and what happened was the judge was asking me so many questions that in that time period, the 5 minutes got completed, and I was not able to say the prayer. So the prayer got left out completely. So what to do in that? I mean, at the end they give you that reminder that you have 30 seconds left. But at that time, what happened was some of my oral submission was left as well, and my prayer as well. So what to do at that time? Should I continue or should I just move on to the prayer?
Those complicated situation, you just seek more time from the bench. You can just ask your lordship, this council would wrap up all the things within 30 seconds, or this council seeks more 1 minute or 2 minutes to complete its arguments. So if the time schedule of that particular competition is not like stringent or not strict, then obviously judges will give you 1 minute, 30 seconds, or 2 minutes, depending on the judges and the time format of that particular competition. And in by taking that time, you can use answer all the queries. If you left something, you can give your oral arguments that you have prepared, and you can also use that time for your prayer. Yeah. So you have to
So the
just
next,
ask for the time thing. As beginners, even I didn't know this. So the placard came, that time left. I wrapped up all the thing and came back saying nothing. I didn't even beg for time. So don't do that. Always beg for time. If judge is kind enough, then he will surely give you. Yeah.
yeah, there is one question. How to read long judgments effectively and thoroughly?
Okay, effectively and thoroughly. Now, if you are, as I said, if you are using case find, or if you are lucky enough to have SEC or Manupatra, there would be placitum, as we call it in legal term, placitum. Placitum contains all the important things, all the important arguments, facts, and what has been held in that particular case in a short format, in 1-2 pages. So if you read that particular thing, you will get to know that, okay, this case will be helpful for me, or this case will be helpful for the respondent, and I should keep it for respondent, or I should keep it for petitioner, or this case should be discarded by me. So that if there are long judgments, like if you say K.S. Puttaswamy, or if you say Natya Singh Johar, you can read so much, right? That is a 798 or 700 pages judgment. So you have to read the placitum part. You have to search for the keywords that you are looking for. You are looking for privacy, just search for privacy, so that you can find out if this particular judgment is dealing with privacy part or not. If you are dealing with constitutional morality, if the concept that came with Natya Singh Johar, right? So if you are dealing with that, so just like CTRLF morality. So you will get all the points, all the paragraphs where morality or constitutional morality has been dealt. So you have to use both CTRLF, that search option thing, and the placitum part to get accurate things. Yeah. Any more questions?
So thank you so much for the session. Devashish, I have some few questions from my previous experiences.
Yeah, Padmes is saying something. Yeah. Yeah. So yeah, okay. So as I was showing you guys the memorial thing, no, in the issues, after the issues, I have mentioned sub issues, and then sub issues, subsets of those sub issues. So as I said, the disputed parts and the smaller disputed parts. The smaller disputed parts, you can take it in your arguments and interpret it either from petitioner side or respondent side, and then use it in your main issue. Right? As I said, whether the accused should be convicted for article for acid attack, right? So you can say that it is humbly contended that the accused in the instant case, the fingerprint of the accused was found on the glass bottle which was recovered by the police. The accused has purchased hydrochloric acid from this shop. The accused has hired this auto and have went to Khan market and have thrown acid on Miss Y. So all the 3 points that I have said just now are the disputed facts, obviously, but they are smaller disputed facts. How they are disputed facts? The question will arise whether the accused have used that particular bottle, whether the accused have fingerprint on that glass bottle, whether the accused has purchased the hydrochloric acid from the acid shop, right? Whether the accused was present in the auto. So these are all smaller disputed facts, right? From both the sides. So you can use all these things and convert it into your arguments or sub issues within the umbrella of the main issue, right? Did you get this, Padmes? Okay. Yeah, Raksha,
You can ask your question.
Yeah, so I have list of few questions which I wanted to ask. So, like on a personal note, Devashish has, helped me in, like in my previous moods, and those questions were really tricky, and we were not getting answer. We were planning to drop out of the mood, but he really helped in the same. So I have few questions. Like in the blue book, like you said that we need to mention, for example, the magic land we need to mention in the whole memorandum.
Yeah.
So what if in the blue book section, I mean the citation part, the notes, we write Indian Constitution ART, this particular article. So do we need to make it Indian Constitution or the Magic Land Constitution?
No, in those things you can mention Indian constitution. That will be taken into account because in statement of jurisdiction you have already mentioned no that constitution of Magic Land will be perimetria with the constitution of India. So when you are mentioning particular article from the original book, you can write ART dot 136 comma Consti of India. The like depends on the blue book citation
Okay,
authorities. So you can
yes,
mention.
okay, thank you so much. My next question is, when we really researched it thoroughly, and we get to know that what exactly the case is about, and we also get to know that the opponent or the defendant which is trying to state some point which is not relevant to our case, but he's stating the same thing, and his research is not exactly to that particular topic we are talking about at that moment. So, like in a previous moods, I've seen that judges, even though their cases, their points, which is not relevant to the case, they state that, and they also get more marks, and their marks didn't get, it's not deducted. The marks is not deducted on the same thing.
Okay, so now on this thing, I have also faced a situation like this in like a few moot courts. So what happens in those situations is that either the party who is stating wrong things is fluent enough, then your team was fluent enough in like oratorship. So what there are some judges who give marks on the basis of oratorship instead of arguments or the substance of arguments or how you are substantiating or satisfying the court. They will just see that how this team is speaking, how that team is speaking, and who is speaking in a better manner. That team will get more marks. That would be a probable situation because I have faced that personally. Now, regarding you said that they were saying something beyond your fact sheet or containing something else. So, like I don't know the exact fact sheet, so can judge on that thing. But most probably they would be better in English thing, oratorship than your team. That's why they got like more marks.
Okay.
So it happens. So don't take it to your heart and like disheartened. There are judges who do this, and I have seen in course. They take teams who are fluent.
Yes, okay, thank you so much. My last question is on cases like, yeah, there are teams which like 150 or 101 cases, and we are at like 20 cases only, or even 10 cases for a particular memorandum. So in that particular scenario, how to really research in depth that we get cases from very intricate points of law. So what
Yeah.
can be done on that?
So for the, getting more number of cases on a like same point or similar point, you have to first of all, as I said, you have to read commentaries, right? For now, locus standi thing, as I am saying, there would be cases in the commentaries from both the sides. So you can take 10, 13, 14, whatever number of cases that you get from one commentary. Now, when I said read commentaries, you can read more than one commentaries. Right. Whenever I do moot courts, I read two, three commentaries, 4, 5 commentaries on a particular law. Like lately, I was doing a trial on NDPS Act. Right. So I have read around 6 commentaries on that NDPS Act. There were 5 sections only that we are dealing in that problem, but I have read 6 commentaries. Why? Because to get more number of cases, because to get broad idea on those particular 5 sections. So don't restrict yourself to 1, 2 commentaries. If you have 1 month, 2 months time and there are no examination assignments or anything, then go beyond reading 1 commentary, 2 commentaries, 3 commentaries as per your like convenience. So by that you will get more number of cases on a particular point. Now there is a feature in Manupatra, even there is a feature in case mine. Okay, so if you like search for a case which is dealing with constitutional morality and you got that case in case mine, there would be a feature. I can show that right now, But there is a feature like do a research on that case mine thing and open it and do that. You will surely get it. There is a feature which will give you all the cases that have used this particular judgment. Now, suppose we are saying case Puttaswamy, right? There are subsequent judgments which have used case Puttaswamy. So you will get all those judgments. So now you have to just see that if you are taking a particular portion from case Puttaswamy, if you are taking right to privacy is an integral part of Article 19, right? If you are taking this, then just see that all the subsequent judgments are taking that particular thing or that particular paragraph or that particular contention or not. If they are taking, then you can use all those cases with case Puttaswamy's case. So you have to do that research. Even in Manupatra also you will get a feature wherein it will like in the bracket of a particular section it will say that 18 plus documents or 200 plus documents. That particular thing means that this particular case has been cited in 200 cases or 80 cases. So you will get you will get a huge number of cases from like on that particular point. So you have to just open all the subsequent cases and see if they are using this particular part which you are referring from the initial judgment or not. So by that you will get a number of cases.
Okay.
So yeah. Any more questions from anybody?
Mohini, we have a question in the chat box.
Yes, Myra. Myra is asking.
I will read it. Is it compulsory to write verifications at the end of the written material?
Verifications.
Yeah, at the end of the written material.
Written like memorial thing. You are
Yes,
like
yes, memorial, yes.
Verification that SD and counsel on behalf of the respondent thing, I guess. She is pointing out.
Mara, will you please clarify your question in the chat box or unmute your mic?
If you can ask orally, then that would be better for me to understand things. Is she there, like in the session right now?
Yeah, she's there. By the time she writes in the chat box, anybody else? Do we have any more questions? Okay, Myra, so can you please drop some clarification about your question in the chat box itself?
Now till then she says about her question. I would also like to mention one thing that there is a Supreme Court decision which says that from which websites you can submit judgments to the Supreme Court, right? Which will be authentic. So from aci.gov.in, as I said, from judice.nic.in, as I said, from SEC or from Live Law. These four websites have like backing of Supreme Court, and the judgments downloaded from all these four websites are acceptable in Supreme Court in real. Right? You cannot give judgments from Indian Kanun, you cannot give judgments from case mine, you cannot give judgments from Manupatra even. Manupatra is discarded recently. Okay. So you can use all these search engines for getting cases and all, but don't submit cases in your compendium from downloading from these websites. So that is one thing.
Risha, you can wrap up the session. We don't have any more questions.
Okay, so now we have come to an end of our webinar. We would like to thank Devanshish for taking out time, and we would also like to thank my venture members who and other participants who made this webinar possible. Thank you, Devanshish.
Yeah, thank you all the organizing committee, and I am like astonished that you guys are in second year and you are organizing all these things in spite of having senior college. So that's a like a commendable job for you guys, and obviously your batch will be setting a benchmark for all the juniors coming up in all these years. So that's a commendable job, Raksha and her team and this committee. So yeah, thank you for having me here today, and I hope like I have clarified like something about Moot Court. And if you have any further questions, if you get any questions subsequently, you can ask me anytime. Like, don't call me, ping me up. You can take my number from Raksha. Okay. If you need any help in any moot court, you can also ping me about that. You have any doubt about moot court, how to go about it, what strategy you should follow, you can ping me for that also. So yeah. Thank
We
you for
have,
everything. I'm highly
like
honored.
Myra has written something. Mohini, please read out.
Okay, the thing where the plaintiff states at the end of the memorandum that declare that what is. Okay, yeah. Oh yeah. Who is she? Myra. Okay, yeah, Myra, this particular thing is like written in real courts. If you give affidavit or if you are submitting a petition before a real court, High Court, Supreme Court, or subordinate court, then you have to mention in your affidavit that all the facts or contentions that I am making in the attached petition or above mentioned petition are correct as per my knowledge, and I am identifying the same before in the court in the presence of the advocate. So this is not required in the moot courts per se. So you don't require to mention this in your memorial. But this is a practical aspect. You guys should always remember that there will always be an affidavit attached to any petition, any suit, or any interim application, anything that you file before any court. So there will be an affidavit mentioning this thing. Verification thing, yeah. She was saying that. The heading is verification, and then this particular thing is written in the petitions, in the affidavit part. Yeah.
Thank you.
Thank you, Devashish. Thank you so much for coming to our webinar. Thank you so much to all the participants. I would want the committee members and the participants to stay back.
Yeah. So shall I leave from the
Yes,
meeting?
sir.
Can I leave?
Yes, sir.
Okay. Yeah. So thank you all of guys. All the best, and keep mooting.
Thank you so
Thank
much.
you so much.
Thank you.
Thank you.